Well, thank you. Welcome everybody. Bienvenidos a todo el
Welcome,
mundo.
everybody, everyone who is listening to us via the link to this panel discussion and debate on Pavez, Fulton, and the future of religious liberty in America. Joining us today, first of all, Senator Mike Lee, State Senator for Utah, a graduate of Brigham Young University in Provo, who was an assistant attorney for Supreme Court Justice Samuel Alito when he served on the federal 10th Circuit Court of Appeals. In addition, the senator has vast experience as a trial lawyer in constitutional matters, looking at the fundamental freedoms of his fellow citizens, including their religious freedom. We are also joined here in person by Montserrat Alvarado, who is the Vice President and Executive Director of the Becket Fund for Religious Liberty, an organization which she has been a member of since 2009. From there, she has led strategic communications initiatives that have secured victories for religious freedom in a number of important cases, the most recent being Sharon Fulton's case against the city of Philadelphia. Joining us via the link is Branislav Marylage. Branislav is a partner in the law firm of Marylage, Carcamo Bush in Santiago, Chile, advisor to and former director of the National Institute of Human Rights of the same country, and a professor of the Human Rights Clinic of the Alberto Hurtado University. In addition, Mr. Marylage is one of the two lawyers representing Sandra Pavez in her litigations against the state of Chile and the Inter-American Court of Human Rights. And finally, we are joined by Juan Navarro Floria, PhD in law from the Complutense University of Madrid and professor at the Pontificia Universidad Católica Argentina. He is a founding member of the Latin American Consortium for Religious Freedom and the Argentine Council for Religious Freedom, having chaired both bodies. He has published more than 12 books and 100 articles in his area of expertise and participated in the Sandra Pavez case as amicus curiae. I cordially welcome you all to ADF International for this panel discussion, and by way of introduction, very briefly for those of you joining us remotely, today we are going to discuss two cases, one of which has already been decided, which is the case of Sharon Fulton with the city of Philadelphia by the Supreme Court of the United States, and on the other hand, the case of Sandra Pavez, which is pending before the Inter-American Court of Human Rights. In the Pavez case, Professor Pavez was a Catholic religion teacher in a school under the municipality of San Bernardo, Chile. When the local Catholic diocese learned that she was involved in an amorous relationship with a woman in contravention to the teachings of the Catholic Church, on whose behalf she taught religion classes, she was informed that she could no longer be certified as eligible to teach the Catholic faith on behalf of her church. Notwithstanding the foregoing, the teacher continues to be employed at her educational establishment, where she is still employed to this day. Ms. Pavez sued the state of Chile before the Inter-American Court of Human Rights, demanding to be reinstated as a Catholic religion teacher, alleging that she had been the victim of discrimination on the basis of her sexual orientation and that her right to work and her right to private and family life had been violated. In the Fulton case, to conclude, and here Montserrat can also clarify, as Branislav did, in that case, Sharon L. Fulton, together with Catholic Social Services, sued the city of Philadelphia for discrimination, and not only for discrimination, but also for impeding the exercise of her religious freedom, in that they were not allowed, or would not be allowed, to continue working with the city because of their beliefs about marriage between a man and a woman. But the U.S. Supreme Court ruled unanimously in June that the religious freedom protected under the First Amendment had been affected by excluding them from the foster care system. So, without further ado, we turn to the opening remarks, beginning in this case with Senator Mike Lee.
Thank you so much. Thanks for that kind introduction. And I also want to thank my friend Gary Doxey for inviting me to participate in this. It really is a pleasure to be here speaking with you who do so much work to protect religious freedom and to study and understand its ramifications. I want to talk a little bit about how these cases touch on religious freedom and how they each represent a common set of themes that really do threaten to undermine religious freedom in the United States and throughout the world. We have to remember at the outset that to understand religious freedom, you have to understand its opposite, or you have to understand at least what it is that we refer to when we refer to religious freedom. It's best understood when you remember that government is not an omnipotent, omniscient being. It doesn't have arms to embrace us. It doesn't have a heart with which to love us. Government is force. It's the official use of collective coercive force. And it has a reason to exist. We need governments to protect life, liberty, and property, to make sure that we don't harm each other, take each other's things, or fall victim to those who would invade us. The further afield you get from that, government force just becomes force. And it becomes force that's not always justified. We know certain things about human nature. We know that human beings, when they get a little authority, as they suppose, they start to abuse that authority unless that authority is carefully kept in check. Nowhere does that manifest itself more clearly than with respect to religious freedom. In the area of religious freedom, it tends not to be those who hold mainstream religious beliefs who are at the tip of the spear in terms of having their religious liberties undermined. It tends to be religious minorities, those who hold minority views. And in a country like ours, in the United States of America, basically everyone falls into this category in one way or another at one time or another. It's one of the reasons why religious liberty has been able to flourish here is because we're a nation of heretics. We were founded by heretics, and we've breeded more heretics, and I'm one of them, and I'm proud to be one. But that's how you foster religious freedom, is you learn to respect heresy, because people have a right to believe and worship and otherwise exercise their religious freedom in the manner they deem fit. Let's talk for a minute about the city of Philadelphia versus Fulton case. In that case, we've got some very good news in that the Supreme Court acted 9-0 to make clear that the city of Philadelphia had in fact violated the free exercise rights of Catholic social services by imposing a secular restriction on the Catholic Church that really did violate religious freedom. It did so in a way that was helpful. It was good to have all 9 members of the United States Supreme Court saying that that's not okay. You can't just identify something that the government disagrees with, something that is the inexorable command of your religious belief system, and say you're not going to be able to participate in this program anymore because you don't do what we like. By the way, Catholic Charities and other religious organizations have been doing this in one form or another, not just for decades, but literally for centuries. One could argue for millennia. And so the fact that the city of Philadelphia would deign in the first instance to have the authority to decide who may and may not do this is itself an indication that something about the relationship between a government and its people has gone dangerously astray. That's something that has to be addressed. And fortunately, under our Constitution, we have ways of addressing that through the court system. It's always my hope and expectation that we can address those things not exclusively through the courts. In our system of government, they need to be addressed simultaneously through all 3 branches of government, including the 2 political branches. You can't ever rely exclusively on the courts. But let's get back to the court's approach in this case. The Supreme Court had a clear shot at overruling Employment Division versus Smith. Employment Division versus Smith was a dangerously wrong turn that the court took nearly 30 years ago that basically made it impossible for the courts to recognize judicially granted exemptions from generally applicable laws. This was a break from precedent. It was utterly detached from any semblance of an attachment to the text, to the original understanding, to the meaning of the Constitution, or to many hundreds of years of Anglo-American legal tradition. The court invented out of whole cloth this rule that has been the source of a lot of litigation and a lot of problems. So, and in this case, there was no victim. This was a particularly sympathetic case, as manifested by the fact that all 9 members of the Supreme Court agreed that what the city of Philadelphia did was constitutionally indefensible. What I find also indefensible, albeit in a different light, in a different scenario, is that we couldn't come up with the majority of the justices who are willing in this case to overturn Smith. This was a really good opportunity. I suspect many of them who favored overturning Smith must have been asking internally their colleagues, if not us, who, if not now, when? In what better scenario can you imagine an opportunity to overturn Smith? I found uncompelling Justice Barrett's explanation in her concurring opinion as to why Smith shouldn't be overruled in that case. Her explanation was essentially, I'm not sure what we'd replace it with. I found very compelling the statement of my former boss, Justice Alito, to the effect that, well, we know exactly what to replace it with. It's already there. Let's go back to the pre-Smith standard. So I look forward to discussing this in the Pavez case as our discussion continues today. Thank you.
Thank you very much, Senator.
We now turn to Branislav Marylage for his opening remarks. Go ahead, Branislav. Branislav, can you hear us? Thank you very much for the invitation. And also, thanks to all those present who are watching us online. Well, we were talking about the Pavez case, about what it represents from a factual point of view, from that perspective concerning the possibility of setting a precedent in the Inter-American Court of Human Rights on such a delicate area as religious freedom, and specifically on the freedom or regulation of religious classes in a public education system. Whatever the Inter-American Court of Human Rights rules, this is a major case. It's a case that allows us to enter into discussion. In this case, Article 2 of the American Convention, an article that had not been very much developed in the contentious jurisprudence of the court, the case law, but rather tangentially in some reports of the Commission. In some quite old reports of the Inter-American Commission, there is reference to this in the first cases, mentioned in connection to visits in Cuba or Central America. From a point of view beyond the facts and the law, however, this case is also important because, from my point of view, much of what we need to look at is what the Inter-American Court is going to rule. At the core is, there isn't a core desire to eradicate the spiritual dimension of people. I'm clearly showing counterpoint with respect to many people who have participated in this case, especially from the state. This case is not going to eradicate or try to destroy faith. This case is not about questioning religion. This case also has nothing to do with the state taking a little more space and starting to become more and more authoritarian in order to invade the religious dimension. That's not the case. Moreover, I fully agree with the senator that the state cannot interfere in people's lives, especially in their spiritual lives. Even when the state moderates religion, when it integrates religion, or religion integrates with the state, you just have to look at the history. Now, the state also cannot be so paternalistic as to say that the salvation of the soul is only through one religion. But understanding that religion has an autonomy from the state also has to be neutral in some way in order to be able to guarantee the freedom of religion of all people. So here we ask ourselves, and I think this is the situation here. When can the state intervene in a religious act without infringing on the religion itself? Because, for example, although it may appear as an extreme example, I have stated it this way. The Inter-American Court for a long time in the name of religion, for a very long time, saw the preservation of certain customs. They were just justified. They were justified under the religious dogma or under the form in which the dogma was read at the time of one or more religions. Religion, can it support torture today? Clearly it cannot. So the question is not about whether or not we are going to contradict religion, but the question is how religions are adapting to our times. What are the reasons and the time or the way in which religions are getting used to common and neutral criteria. Human rights are shared standards, and it is our aspiration that all different people, regardless of religion, have certain guarantees facilitated to them. And this defense of human rights, recognizing, of course, the spiritual dimension, is defining the limits and the boundaries between a practice that's prohibited from the point of view of human rights and a practice that might be permitted. So what we propose to ask in this case is whether discrimination based on sexual orientation is reasonable, regardless of whether or not this person was a public official. Is a person's sexual orientation a permissible ground for excluding him or her from a creed or from professing a religion? It's a very broad term. I could not say that certain personal characteristics can be relevant when one is living the dogma itself, the religion, the mass, the sacraments of some religion. But that same way of understanding these limitations, taken to a context where it all has to be more reasonable, where there are requirements to be able to teach, where there are ways of seeing the public exercise of a position, tells us that there are certain characteristics that, it seems, are not reasonable to define when a teacher can or cannot teach. Where does the limit lie? Whether sexual orientation is relevant to teach or not is what the court is going to have to decide. They'll have to set limits, potentially. This is a very complex thing, and we are in a case that highlights that complexity. From my point of view, from the point of view of several people who have also supported this case, almost all of the amici curiae who have joined, it is reasonable that religion, in this case the Catholic religion, could be subject to limitation. It was probably something quite confusing from a legal point of view, but in broader terms, the manifestation of religion cannot be the same as if... Oh, I'm sorry? Yes, I'm sorry. I just wanted to stop there a moment, and we'll continue to analyze further. Thank you very much. And now we're going to move on to Juan Navarro. Go ahead, Juan. Thank you. Can you hear me all right? First of all, good afternoon, good morning. It's a pleasure and an honor to be here with you. I see some old friends that I haven't seen in a very long time, and I think it is very important that we have this opportunity to discuss such matters. I shall limit myself to talk about the Pavez case. The Fulton case is very important, but obviously it is part of a long tradition of the U.S. Supreme Court rulings on religious freedom. On the other hand, however, the Pavez case, as was just said, may be tremendously innovative. It is an opportunity for the Inter-American Court to make a statement for the first time and concretely on the issue of religious freedom and the protection of religious freedom in the Pact of San Jose, Costa Rica. As mentioned previously, only in one case did the court deal directly with Article 12, and it did so in a rather superficial manner. And in other cases, it touched on it in a tangential manner, speaking of other rights. Without any doubt, in the Pavez case, what is affected here is religious freedom, and therefore, the first thing that is striking is the fact that the Inter-American Commission, when it brings the case before the court, practically ignores the issue of religious freedom. And this is very serious, because clearly, religious freedom is at stake here. And in every situation, in all cases, there is an issue of how to coordinate, how to standardize many rights, which certainly are of value on the part of Miss Pavez, with religious freedom. I believe that one of the important aspects is that what is affected in this case is religious freedom in its collective aspect. Religious freedom has this particular characteristic that it's got two dimensions, individual and collective. And this is clearly stated in Article 12 of the Covenant. This brings up an issue that is the Convention, which is the Advisory Opinion 22 of the Inter-American Court, where it says that basically legal persons, unlike what happens in the European system, do not have or cannot raise issues affecting their rights before the Inter-American Court. Because the Convention, the court said, basically guarantees the rights of individuals. But it made two important exceptions. One is for indigenous peoples, and the other is for unions. And it left other possibilities open, among them that of religious groups. I believe that Pavez, and in fact, I presented this in the amicus curiae before the court, is the opportunity for the court to recognize that churches and religious life have rights, and therefore a standing before the court. And this is not only inconsistent, this is not only not inconsistent with its advisory opinion, but it follows the opinion. Among the rights of religious freedom in its collective aspect, I believe that the right of autonomy of religious confession stands out. And it's not only the right of the religious denomination to set its own rules, but also to organize its rules and to decide which are the conditions to be part or not of its own denomination, to choose its ministers of worship, and, of course, to organize the teaching of religion in and out of school. There's an issue that people tend to confuse, it seems, in this case, and it is the fact that the lawsuit is against the state of Chile. Of course, Chile is an interested party in it. But, well, because what they are trying to do is make Chile change its system of religious teaching in school. And it is a system, I must say, that's perfectly compatible with religious freedom, with human rights, and with the secularism of a democratic state. It's a choice made by Chile that is similar to that of many countries, and that, for me, should go without objection. But what would be affected in the Pavez case, if what has been raised is accepted, is religious freedom. Not only of the Catholic Church, but of all the confessions. It's 16 religious sects. The right to teach was recognized, and this is evidenced in an article presented by the Catholic Church, the Anglican Evangelical Church, the Jewish community, the Islamic community, and the Orthodox Church. All of them feel that if they are restricted from choosing who is the person who can teach religion, their religious freedom would be affected. Just one more thing to finish up, and it's this. Religion clearly is made up of different components. The president of the Inter-American Court herself, in her capacity as rapporteur on religious freedom before the United Nations, explained in a report that religion is made up of three things: worship, belief, and practice. Morality, the practice of a code of conduct, she says, is part of religion. Whoever is going to teach religion must have, in his or her personal life, a conduct that is consistent with what the particular religion teaches or intends to teach. What we're seeing is that there is an opposition between Miss Pavez's choices, which are perfectly legitimate, and the teachings of the Catholic Church. Miss Pavez has every right That. Yes, yes, absolutely. Thank you very much. And finally, to end this initial round, we will give the floor to Montserrat. Thank you very much. It is a pleasure to be here with friends and Dr. Navarro Floria. It was very good to see him again and to hear his comments. I'm going to give my comments, to go more quickly, in English, but I wanted to greet you in Spanish because it gives me great pleasure as a Mexican to be here talking about issues that are so important for the Mexican community internationally, and also as an American, talking about the Constitution and how the robust protections that the United States has can be, in a way, a map of how we can carry out these protections for the international communities and, in this case, for Latin America.
So I'm going to talk a little bit about some of the background of this area of religious freedom law that I think is relevant to the comments that Dr. Branislav gave and expand upon what Dr. Navarro Floria said. Really quickly, I work for the Becket Fund for Religious Liberty. It's a nonprofit law firm that defends religious freedom here in the United States. And our focus in the Pavez case is really to give the structure of what has happened over the last 11 years in religious autonomy law here in the U.S. at the Supreme Court and at the circuit level appellate courts, and what is possible for religious autonomy in the Inter-American Court of Human Rights, and specifically for Chile. The last 11 or so years of religious autonomy law in the United States have really changed and evolved very quickly, in that the Supreme Court has said that there is a sphere of protection around employment issues, issues of hiring and firing, issues of who gets to teach the next generation what your faith believes, who passes on the faith to the next generation. That's incredibly important, because one of the things that often comes up is that there's a government interest in protecting people from discrimination. This is one of the main pieces that gets brought up in a lot of these cases. Now that we have this new resurgence of LGBTQ rights, or sexual orientation and gender identity rights, there's this supposed conflict with religious liberty. I say supposed because I do believe that it's important to realize that religious freedom is a human right. Religious freedom isn't a right that goes away when you have conflicts with your own gender identity. Religious freedom is preeminent. It is the benchmark. It's the canary in the coal mine that allows you to know that in a place like Saudi Arabia or Russia or China, you are being gypped of your first freedoms, of your human dignity, when you're not given free speech, free press, free expression, religious freedom. And so putting those countries aside, which we outlined in our brief as just falling short of the reality of the International Conventions on Human Dignity, we can talk about what happened here on religious autonomy. So the first case that I want to bring up is Hosanna Tabor. In 2011, you had a non-sexual identity conflict where a teacher wanted to sue her school for getting fired. And she tried to bring in all kinds of protections, anti-discrimination protections. And the Supreme Court then, 9-0, pre-Kavanaugh, pre-Barrett, pre-Gorsuch, pre any of the changes, when you had Scalia and Kennedy on the court, said, this is a non-starter. 9-0, you do not get to intervene, bring in the arm of the government in the hiring and firing decisions of a church. That's great. And they named something. They named the ministerial exception for the first time. This piece of church autonomy doctrine that speaks to who religious ministers are. Okay, fast forward to last year in the middle of a pandemic, 2020, we have the Our Lady of Guadalupe case. What happens there? You have a 7-2, still a majority, decision that says that church autonomy still reigns. You go from ministerial exception, which Justice Alito noted was a misnomer. It is discriminatory to say ministerial. Why? Because Jewish communities don't call people ministers. Buddhist communities don't call people ministers. It's a Christian term, and by that it's an evangelical Christian term, because the Catholic Church doesn't name every single person a minister. And so you have this broadening of the understanding of what it means to really live out your religious freedom as an institution and as a church community. So that's a very important thing to remember when you're thinking about changes in church autonomy protections and this sphere of protection, where the analysis that I believe Dr. Branislav was getting into of, well, does the church have a compelling interest in who this person is and making sure that that person is the one that teaches the faith, they don't even get to that analysis here in the United States. We don't even go there. We don't touch it. There's a protective layer around it. And so then, how does the Fulton case, which Senator Lee described so well, this idea that a church ministry shouldn't have to certify a same-sex couple shouldn't have to certify a marriage that goes against his own teachings in order to be able to partner with the government. And we know that in the Pavez case, we're talking about a government-sponsored school. Even so, even then, you don't check your religious freedom out the door the moment that you partner with the government in some way to do something good. And here I call it the government takeover or foster care, because they came in, took what the church was doing, and then tried to regulate it themselves because they think they know how to do it better. The government tries to do that all the time. Why do I bring in the Fulton case in this litany of cases? Because you have 2011 with Hosanna Tabor, then you have 2015 with the Fernandez Martinez case, which tells you that you're going to apply the same church autonomy principles internationally. Then you have Our Lady of Guadalupe, which again tells you 7-2, majority decision, don't touch church autonomy in these broader contexts. And then you have Fulton, which says in conflicts with issues of sexual and gender identity, you do not have to get into the church's relations there as well. So that is kind of the hope, is that Pavez will take that on and analyze that as well.
Indeed, thank you. Thank you very much, Montserrat. And now I'm gonna give way to the questions, both from myself and from the audience. We already received one question online, and this is for Senator Lee. A reporter from the Christian Post asks, regarding your statement that the United States has had a flourishing history of religious liberty because we are, quote, a nation of heretics. Much has been made in recent years of the rise of the religiously unaffiliated in the United States. Do you believe this trend, which some argue is a rise of heretics, will help or harm religious liberty in the United States?
Look, anytime you have more people who can be sympathetic to a cause, it becomes less of a perilous right, because people understand that they're all in the same lifeboat. So I want to be clear in answering this. So the existence of more people who are unchurched or who are perhaps even agnostic, obviously they have every right to believe whatever they want. That is itself a form of religious belief. Deciding not to be religious is an exercise of one's free exercise of religion. So that should never be undermined. As religious people, those of us who are religious, also have to understand that as more people count themselves among the non-religious, we become, as a group, even more of a minority. Each one of us who belongs to a different sect of purported heretics becomes even more heretical. So it's why it's important to outline this at the outset and agree that we're going to defend it, agree that the principle needs to be defended regardless of its popularity. Remember, beliefs that are mainstream generally don't have to be litigated, because generally governments will defer to them, because governments don't want to run afoul of what a majority of the people think. But that's exactly why it's so important to stake out the principle in advance. That is concerning, but it's manageable.
Senator, as a follow-up to that, and we had discussed this before in terms of, there's always such pressure and focus on what the courts can do with protecting religious freedom. And we tend to forget about the legislature. What role do you see as a legislator yourself in terms of protecting freedom of religion? What can be done from the legislatures?
As the late Justice Antonin Scalia used to say, any tin pot dictator can have a Bill of Rights. And in fact, most tin pot dictators do have a Bill of Rights. Most of them have bills of rights that look comparable to, or in some cases, even superior to ours. But whether or not that Bill of Rights makes a bit of difference, whether it's worth any more than the paper on which it's printed, has entirely to do with how a system of government allocates power. And if the accumulation of power that can lead to the subversion of rights is allowed to persist, and if power can't be made to counteract power, that's where you run into trouble. So that's exactly why I believe emphatically that the answer to the question is yes. In a three-branch system of government like what we have in the United States, we have to push simultaneously on all three levers. You have to, it's like a three-legged stool. You apply pressure to all three legs, you'll find the weakest leg. You also figure out which legs are stronger, and that may vary from one moment to another. But there is grave danger within our system of government, particularly in the United States over the last few decades. We've come to regard many constitutional issues as issues for the courts. These are issues for the 9 lawyers wearing robes. And while that's true in that they get to decide cases and controversies properly before them and within the court's jurisdiction, it's dangerous to view that as being synonymous with what the Constitution says. So in defense of the Constitution, we've got to be ready, as Congress did in the wake of Employment Division versus Smith, ironically authored by that same Supreme Court justice. The Congress passed overwhelmingly the Religious Freedom Restoration Act. That's the kind of response to each branch that we need to always have. Our religious freedoms have to be fought for and won over and over and over again. And that has to occur in all 3 branches, always.
Thank you very much, Senator. Now,
I have a question for Branislav. Can you hear me all right? It seems that you can. Branislav, the question that I would like to raise is the following. I think we have a basic agreement about the existence of religious freedom and some doubts about its content and scope. But is there a context in which, or perhaps some changes in the circumstances, in fact, of the cases in which what happened to Professor Sandra Pavez would not be, in your view, a violation of human rights? Or asked differently, in your opinion, and thinking about what the court may decide, what do you think is the content and scope of religious freedom when it comes to the selection of teachers, specifically of the Catholic religion or of any denomination?
thank you so much, Senator.
Yes, thank you very much for the question. Now, this is a case that, as was said, is a case that was taken from the Commission to the Inter-American Court as a discrimination case per se. A right-to-work case. Discrimination, private life. Of course, that case has a religious aspect to it. But that was not the main alleged violation. Because in the logic of litigation in the inter-American system, beliefs have fundamental rights. Or don't have fundamental rights. Therefore, they could not allege that their rights are at stake. This is a right that is important because the limits of the environment of what is determined in terms of capacity, equality, and non-discrimination has a direct effect on freedom. So, in this, freedom of religion is not a subjective right. It is not seen as a right or that another or something that another person is infringing against Sandra Pavez. In reality, this limitation is an objective right. It's not logical for the Inter-American Court to hear a case to protect one right by violating another, however. And it's quite challenging, so therein lies the debate. This case, within the national context, the context of this case is not one of worship per se. If a religion teacher comes, she's not a minister in the Catholic sense. She's not a person who officiates in religious activities, but she is a teacher in a public school, which is not a denominational public school. It's logical that in a denominational public school that follows a religion, teachers would follow that religion. In a public school that represents the state, a similar logic would be followed. It should not be such a determining factor that a religion, the Catholic religion, determines Sandra's practice. So this is the case we're considering here. Now, what the court has to do, from my point of view, is simply to say that there is a violation of right or that there is not a violation of a right. What they have to determine is whether or not ministerial exception, from my point of view, I don't think it applies, but whether or not it applies. The criteria that the court sets based on distribution, conditions, context, employees, and who finances the facility, how it's used, what accreditations are present. They should be set with criteria because those criteria not only protect people like Sandra, but also protect that religion has limits. Of course, but that is the discussion we're having right now. To reiterate, of course, my point of view is not to crush religions by or for the state, but from no point of view can one exclude a person because of his or her sexual orientation. Because when Sandra Pavez was teaching, according to my information here, that was not known. And she hasn't changed as a person. It's just more people know this about her now. And that can't be a criterion to exclude a person. Thank you. So that we can make a counterpoint with respect to that. Juan, I think that here we can generate discussion, at least about what Branislav mentioned. Would the ministerial exception apply or not? So we're going to assume that label that the Inter-American Court has not used and that we may disagree about its use, but Branislav considers that it should not be applied. Do you share that opinion? Are you of the same opinion? Why or why not? And specifically, if you could tell us in advance what you think the consequences might be of an eventual or potential unfavorable ruling in that sense regarding religious education in in the Latin American region, where this ruling would have a greater impact. I'll begin with that last point. I believe that it is going to be very important because the Inter-American Court intends to make its case law binding on Latin American countries, unlike the United States. This is indeed the case. In fact, there are already cases where gender issues are being discussed. For example, if I've got a case in the Supreme Court of Argentina where they are trying to impose on the Catholic Church that they accept that a person who has made a choice to change their gender be accepted as that new gender in all aspects. Specifically, a person who was born male but has now become a woman. According to the Attorney General's office in Argentina, this individual can now, for example, marry another man in a church. This is what we're saying should not happen. The state cannot be telling religious denominations what they should or should not believe. The state cannot impose a belief or a moral standard on religious denominations. This is the point of discussion here. In the case of Sandra Pavez, regardless of whether we can define her as a minister or not, she is a religious teacher. In a system like Chile's, where what is taught is religion from the confessional point of view, you need to recognize it's not a generic or theoretical teaching of religions. It's catechism. It is the teaching of a religion with programs approved by religious groups where families request that their children receive teaching on that religion and not another. In that sense, the state cannot, and neither can the Inter-American Court, tell every religion what it must teach as its own doctrine and morals. And in that sense, I believe that a balance must be achieved. It's not about crushing rights, but about balance. Ms. Pavez, who has made a life choice that is perfectly legitimate, did not lose her job. She kept her position. She was able to keep her income. She has kept working. But what she cannot do is be a Catholic religion teacher when her life choice, which is legitimate, contradicts what the Catholic Church teaches in matters of morality. It's like if a person who refuses to follow Jewish dietary restrictions wanted to be a teacher of Jewish religion, or as if a Christian who wants to be a polygamist and wants to have a religion of lots of partners and sexual relations with diverse people in their life would want to be a teacher of Christian or Catholic religion. This is an objective contradiction. When people can choose different things for their private lives, how they eat, how they dress, how they act, that's a legitimate choice that they make before the law. But it's contradictory to the morality that sustains the religious confession that they want to teach. That is a clash. Therefore, the state cannot impose on religious denominations a change in their moral teachings because some person has voluntarily chosen to follow a different orientation from what their religion says. It seems to me that this is what's at stake here. Whether the state can impose on religious denominations what they should believe and what they should teach, or whether religious autonomy means that each one can self-define what is to be taught when that religion is taught. Thank you, Juan. And that actually creates an opportunity for me to move on to a question for Montse. Branislav was pointing out that the way the inter-American system is structured meant that this case of Sandra Pavez comes to the Inter-American Court as one in which it is she who is invoking a violation of her rights to non-discrimination. Isn't that... Well, that's not necessarily what happens here in Fulton's case, is it? And that's why it is then presented to us as a case in which a believer, Sharon L. Fulton, or a religious entity can allege on her side the violation of her rights. And you wanted to discuss, as far as I understand it, in that case, what is the standard that should be applied to the state or the government if it has the pretension or the intention to restrict fundamental rights such as religious freedom? What should be the applicable standard and why?
Can I answer in English just
Sure.
to make sure that I'm efficient with my time? The standard was described by Senator Lee, the standard that should be used, and it's a standard that can be replicated with international norms if you follow what has been outlined about human rights law already in the international conventions, which is the RFRA standard. The Religious Freedom Restoration Act creates a balancing test where the government has the burden of proof. They have to prove that there's no other way for them to provide these services or these opportunities for whoever it is that is bringing a case before them. And it also has certain tools that can be used to provide everyone with the rights that have been afforded them. Marian Glennon has a great book that is also 30 years old called Rights Talk that warns against the issues of creating more and more rights, which we have seen here in the US. So what happens when those rights come into conflict? You have the analysis, the free exercise analysis of RFRA. And the Fulton case, and before that, the Tandon cases, the COVID cases, really tested this reality of when is it that the government can reach in and say, hey, I have a really good reason for making sure that I get in there and move things around or violate your religious freedom before I have to have a really good reason, right? If they don't, they have to leave you alone. And there's a new case that just came out of the 7th Circuit last week that was decided in this new environment. And this is not necessarily legal analysis, but I think it's a cultural analysis that we can apply here. The Demkiewicz case did deal with an organist who was in a same-sex marriage. And under this new environment where the Supreme Court gave a 9-0 signal saying, hey, conflicts between same-sex relationships and religious freedom doesn't have to bow down at the altar of gender identity. It just doesn't. They can coexist in this way, in that person, if they want to play within the sphere of religion, they have to follow those religious norms. Why? Because being a religious person isn't something that only happens in your heart and in your mind. It manifests itself in all kinds of ways. And public witness, whether it's Christian or Jewish or a Latter-day Saint public witness in its own Christianity or a Hindu public witness, doesn't just happen in the four walls of your home. And so the analysis of, well, this person has their identity rights or different kinds of rights that have to be asserted here, well, not in the context of a religious group that is dealing with their leadership and leaning on their leadership for the next generation to look at them as religious leaders that they can follow. And if they're openly in conflict, creating scandal within that religious group, they are going to have some sort of discipline or be moved around. And in the United States, you've seen the Catholic Church and many other churches offer different opportunities, offer to place them in different roles that aren't roles of leadership and that wouldn't signal that scandal and wouldn't create that scandal. There are many ways to be compassionate without falling into these conflicts that courts should defer to religious groups on.
Thank you, Monse.
Before I move on to the last question, I am going to ask all the panelists. I want to give a special thanks to the International Center for the Study of Law and Religious Studies, the International Center for the Study of Law and Religion, for being our sponsors for this event that we are delighted to be able to review here together. A question that comes to us from one of our listeners, I think it's pertinent to all of us and connects us directly to the topic of this panel discussion, and that is that even though it comes up in the United States specifically, you say that a lot of the disputes over religious freedom seem to be a conflict between religious belief and so-called LGBT rights. Is it a zero-sum game? Or is there any possibility that these rights can mutually coexist in the United States and generally in the world? Because obviously the Pavez case is framed in the Chilean context. And if that's the case, what is the way in which that can happen? As I say, I think it connects directly to the question of what is the future of religious freedom and the possibility of coexistence in our different societies. I leave the question for the three of us and for the three of you, and let's go ahead and get started with Branislav, I suppose, if you'd like. Thank you. I think that's the key, no? The key is, and I have to mention that it's how does the freedom of pure religion and culture coexist in different states? Also that of democratic debate of human rights. That's the key. There is no other point or issue more central than that. But just because it's been identified doesn't mean it's an easy situation. It's quite complex. From the side of Sandra's defense and other discrimination cases, the only way to establish compatibility and prevent the state or religion from going beyond their own scope is to establish more or less objective criteria, as objective as possible. That means that the requirements or the way of relating one to the other should be as regulated as possible, because when there is no regulation or when something is simply up in the air, a spontaneous regulation could be made or a spontaneous debate could come about, which gives rise to actions that are contrary to common sense and logic. In the case of Sandra Pavez, for me, it's just not sufficiently regulated or established or structured. This is common sense. A person, for the fact of being a lesbian, cannot be eradicated from giving classes. Logic doesn't fit into that. So that's what I have to say on that matter. Thank you very much, Branislav. Monse?
I think that you're asking a really important question where I think Branislav made the point that you're eradicating LGBTQ people in the area of religious instruction, and that's not actually true. Mm-hmm. You're asking a religious group to change its religious beliefs and allowing the government to choose all sorts of tools, non-discrimination laws, laws about any sort of regulation that exists that is created by a state level or federal government can be brought in to leverage it against unpopular religious beliefs. What are we talking about here? We're talking about religious beliefs that in some way or another are either unpopular or misunderstood. And we saw that with the Supreme Court here, where the Supreme Court acknowledged this long tradition of service from the Catholic Church as one that shouldn't be ignored, but is good for society. In the Pavez oral argument, one of the judges asked the question, is it possible for the church to do something good in society? Are you kidding me? It was the most offensive proposition when churches around the world have created hospitals, nursing homes, homes for unwed mothers which don't exist anymore, and I wish they did, because I think that we would have so much more access for women who get pregnant and have no help at all. But those are just a few examples of the great things helping young children on the border. It's 48% of help for migrant children in the United States is done by Catholic charities, if not more. It's crazy to think that someone who uses their religious impulse and wants to do good for society shouldn't exist. Those are the people that are being eradicated.
Thank you, Monse. Juan? Yes. Thank you, Tomas. I would say that the answer to your question is that inevitably we have to find ways in which different views and different ways of living can coexist. And I think that, at least in the West, certainly in America, religions have long since given up imposing on all people certain views, certain ways of living. That is to say, religions do not want all people to believe the same thing, but they are willing to coexist. And in the same way, we must avoid imposing on religions a certain code of conduct, a certain ideology, or a certain way of living. So we must find a way for both things to coexist, so that those who want to live according to other moral guidelines different from those proposed by the religious confessions of the world can do so. In fact, they do. Ms. Pavez has continued to live, work, receive her salary as an employee of the state. What she cannot impose is her particular point of view or her particular way of being to all the believers of the church as a whole or of any group. You have to live and let live. And it's necessary to respect that there are different ways of facing life, religious and non-religious. All are equally respectable within certain basic frameworks. So we cannot impose on churches or religious denominations a certain ideology or morality that goes against what they hold, which is also what societies have held for a very long time, I should say. It's not that we're talking about anything crazy here, but we are talking about the commonly accepted moral code in society until very recently. I believe that different ways of living can coexist perfectly, but just as the church or churches do not impose their beliefs on anyone, neither can we impose on religious denominations a certain ideology, a certain ethical conception that goes against what they hold. Thank you very much, Juan. And well, as we're coming to the end of our time, I will, if you wish, give the floor to each of you for an additional 2 minutes so that you can make your closing remarks. Whichever one of you might want to start, you can go ahead. I'm going to change the order, though, because we have just heard you guys. Monse, maybe some closing remarks? Feel free. I'm going to conclude in Spanish only because it seems to me that it's very important to realize that what we're talking about here is human rights issues, as Juan Navarro Floria said. I believe that also, as Senator Lee said, it's extremely important to realize that the person is a whole person. A person is not someone who just lives their life and can leave their religion aside and not act with it. And the governments have to realize how the world is changing, how secularism continues to rise, which was a comment that was made today. What we have to realize is that the knowledge of religion and the norms that come with religions cannot be excluded. They have to be, if not celebrated, at least accepted. And that governments have to realize that there is a place for those religions that have to be protected. And at the same time, that there are certain secular norms that have to be followed, like the protection of LGBTQ people. And that both things can exist without having to compromise. if we can follow what's happened in the US courts, we're just starting this project, and I would love for this Pavez case to be the beginning of that recognition of the importance of these two things that can exist simultaneously. Thank you very much, Monse. Branislav? Thank you very much. Let's see. I think that we're really taking this debate to the limit. This obviously can't be compared to just any situation. And to be precise, religion cannot be eliminated for the sake of human rights. I think that, of course, in that sense, we all agree. We are trying to determine whether or not excluding someone from a religion because of their sexual orientation is reasonable here. That's from a state point of view, and that needs to be brought out. Sexual orientation is not a person's choice. Sexual orientation is part of a person's essence. Someone doesn't choose it, they live it. In theory, a homosexual person could be Catholic or Jewish or anything. It's the same thing as talking about, within the scope of the Catholic religion, the Jewish religion, skin color, disability, etc. That's the key there. And this is what we're trying to get at. It's irrational. It would be totally irrational if someone said that only blonde people or blue-eyed people could teach Catholic religion courses. It's the same thing. That's the argument I'm making. I'm not saying that the Catholic religion has to change its dogma. It simply has to adapt to situations that are not chosen. And sexual orientation is not chosen. To give an extreme case, if a person in Chile is convicted of sexual offenses, obviously they can't teach in any part of the world. But if a person is accredited, a religion can't rule out any requirement if it's basic or rational. The question is, does that requirement invade religious freedom? No. The question is sexual orientation a basic requirement for teaching? That is the bottom line of the Pavez case. And in order for religious freedom not to be crushed by a series of regulations that's totally disproportionate, minimal criteria must be established. That's the basis for the spiritual protection of all persons. Thank you very much, Branislav. And finally, Juan, to close off the session. Yes, thank you very much. Well, I would like to thank you again for the invitation and thank you for this opportunity to debate. I agree with what Monse said a moment ago. I think it's very important to rescue the value of religion in the life of society, and that religion be respected for what it is, not for what we would like it to be. Our experience during COVID has shown us that religions have been able to play a very important role in caring for the vulnerable and in terms of social action. But above all, religion has a value in itself for the meaning it gives to people's lives, and this must be respected at face value. Religion, I say once more, is not just a set of ideas. Religion is a set of ideas, of beliefs, but it's also a moral code that is preached and which makes people better. It makes people good, and this must be respected. So the teaching of religion has to do with this. Of course, we're talking about education, and education cannot avoid the spiritual aspect. In many Latin American countries, religion has been eradicated from schools. I think that it should be present in schools. And religion should be present from an active point of view, an active, positive point of view, so that we can celebrate diversity. But valuing diversity also means valuing identities, and different identities have to be respected. Not everything is the same, so each religious community must have the right to be able to teach what it believes, to be able to do so freely. Thank you very much, Juan. And well, with that, our scheduled time is over, so thank you very much to everyone who listened to us remotely. Thank you, Montserrat, Branislav, Senator Lee, Juan, and everyone else for being here today. We hope that this will be the first in a series of events or discussions that we will be holding on this and other cases. So we invite you all to stay tuned. Thank you very much for being with us today. Thank you. Thank you, Monse.